SJC-11206, Azubuko versus Boston Public Schools, SJC-11212, Azubuko versus the Commonwealth, and SJC-11213, Azubuko versus Registry of Motor Vehicles.
Good morning, sir.
Good morning to you, sir. The Associate Justice. Okay, my name is Chukuma E. Azubuko. I am the appellant to this case. Based on the submission of the appellee, the only issue in question before this court is the initiative to remove the case from the Suffolk Superior Court in the way of writ of mandamus. I was condemned to pre-filing order at the said court without a substantive and procedural due process. There is no law for such a measure in Massachusetts, but it was on the basis of supplemental jurisdiction or reciprocity principle, which flew from the federal law in the way of a U.S. Code, 28 U.S. Code, Section 1651A. Taking everything into consideration, the order originated from Judge Margaret Hinkle, and based on what I was told, she did not issue that order on her own initiative. There was a prevalence of active domination of will or undue influence on the part of the Assistant Attorney General Salvatore G. Orlandino. That is the Exhibit 1 of my brief. The order was issued on February 28, 1998. It was not in keeping with the law. A well-established constitutional right should not be deprived without in compliance with the substantive and procedural due process. Access to court should not be restricted without first granting the victim a hearing. I never got a hearing before my right was taken away from me. There is no law in Massachusetts also restricting anybody's access to court. That measure was embarked upon on the basis of reciprocity also, or supplemental jurisdiction in the way of 28 U.S. Code, Section 13. The measure was in stark violation of the United States Code 28, Section 1343, which reads that statute giving all citizens the right to federal court access. If I
could ask you one question. There was a case before this court in 1999 by the name of Chuck Wu Azubuko versus Attorney General. Same last name as you, but the first name was CHUKWU. Was that a case brought by you?
1999?
Yes.
I think this is my second appearance before this court, and it was in connection with me being charged for assault and battery without me confronting the accuser.
Okay, well, let me ask you, is the name Chuck Wu a name
that's my name, Your Honor,
that you use?
Yeah, that's my name.
Because in that case, apparently there was an order that said neither the clerk of the court for Suffolk County, the single justice session, nor the clerk for the Commonwealth, the full court, may accept any further filings from the plaintiff unless at least 4 justices of this court authorize the filing. Were you aware of that obligation before you filed these actions here in this court?
Nobody notified me. I mean, as you could see, it sounds like a news to me. I never knew about it. So based on the submission of the appellee, the only issue they're attacking is this case being removed from the Suffolk Superior Court in the way of writ of mandamus, which is in compliance with Massachusetts law. The law in question is the writ of mandamus law in question is, I think, 249, Section 5. So based on the surrounding circumstances for my employment termination, nothing is being contested. The issue before the court again is the removal of the case from the Suffolk Superior Court to the single justice of this court on the basis of writ of mandamus. At the lower court, I was not given, a docket number was given to me, and I was told at the 11th hour that it was issued to me by mistake. I filed a notice of appeal, but on the second thought, it dawned on me, based on the unconstitutional behavior of the said court, which was provocative in nature, so I acted in an iconoclastic manner. The action was on the basis of a writ, then I removed the case on the basis of writ of mandamus. And that is in keeping with the law on the basis of Massachusetts Constitution, Article 11, and the preamble to Massachusetts Constitution, second paragraph. This case is not a new case. I mean, employment case is not a new case before this court. It is modeled upon the case which the court had already decided in this court in the way of Geraldine Brown versus Annie Guerrero, 390 Mass 631, 1983. I quote, it says here, we granted the plaintiff's application for direct appellate review. The defendant has not filed a brief with this court. The defendant, the unsuccessful party below, is thus not entitled to a decision of this court on the reported case, Commonwealth versus Petralia, 372 Mass 452 454 1977. The fact that a case comes here on report by a judge rather than on appeal by the defendant makes no difference. The report must be discharged. This is a landlord-tenant case. Then another case which squarely reflected upon this case is in the way of a case this court also presided over. That is, let me find it. It is not the case of Gregory. The surrounding circumstances has no bearing to the case of Mello versus Stop and Shop Companies Incorporation, which the cause adjudicated in 1988. But let me. Let me skip that. Okay, this is the case I was looking for. This case squarely centers on Robert E. Graham versus Liberty Mutual Insurance Company. The court adjudicated on it in 1984. And some issues came up, which I am interested in the way of career credit. This gentleman, the plaintiff was discharged from Liberty Insurance without a cause. The only exclusion will be endorsement. The case has nothing to do with endorsement or renewal, commission-like compensation. Those were the only exception, but absent that, this case centers on the same precedent. And based on the defendant's submission also, it was intentionally excluded from this case in the way of the law of the land, which is Massachusetts General Law, Chapter 71, Section 41.
Before we leave the subject that was addressed earlier, did you say you were unaware of Judge Hinkle's decision in 1998? because it's attached as an exhibit.
Oh, no, I was aware of the decision of Judge Hinckley, which, as I said before, I mean, I never had the opportunity to confront whoever originated the charges in keeping with Article 12 of Massachusetts Constitution, which is the equivalent of 6th Amendment, confrontation clause, and that legal doctrine is not released in the United States. And the court had dealt with similar issue in the case of Melendez-Diaz, Melendez-Diaz versus Massachusetts. U.S. Supreme Court, I mean, entered judgment in favor of the defendant. That was in 2008. Other relevant cases in keeping with the 6th Amendment will be in the way of Crawford versus Washington, 2004, Davis versus Washington, U.S. Supreme Court, 2006. It's a domestic violence issue, but the defendant never had the opportunity to cross-examine the accuser or the primary complainant.
Mr. Azubuko, I'm sorry, but your time is up.
Okay.
Thank you.
Look.
Good morning, Your Honors. Michelle Hinckley on behalf of Appellee Boston Public Schools. Unless Your Honors have any questions, the appellee is simply going to rest on its brief.
All right. Thank you very much.
Thank you.
All right, please.